Hello and welcome to today's webinar on behalf of Legal Futures, 10 tips and traps when acting for developers buying land. I'm Peter Dollar, and when I was in practice as a lawyer, which I was for more than 25 years in various City of London law firms, I acted almost exclusively for developers buying and developing land. So this is an area that is very close to my heart, if you like. And today we are going to be looking at the following issues. Not surprisingly, there's 10 of them. That's because the title talks about 10 tips and traps. So we're going to be starting by looking at the developer. Understanding your client. What is a developer looking for when they buy land? How do they value land? What are their main concerns? Then, looking at more specific things, I'm going to go on and start looking at easements and rights affecting the land, including rights of light, and can they be dealt with? I'm then going to continue on the subject of easements and rights, but this time the other way round. Not easements and rights affecting the land, but easements and rights that may be needed by the developer in order to do their development, in order that the development works. I'm going to look at adverse possession issues and at restricted covenants affecting the land. Will they be a problem for the development? Then I'm going to look at contaminated land and site surveys, avoiding future issues, planning obligations and community infrastructure, the issues to avoid. I'm going to look at roads and sewers, and that will include things like stopping up, adoption, ransom strips, requisitioning a supply, and so on. I'm going to look at conditional contracts, options and overage, the main traps that arise there. And I'm going to finish by looking at a couple of lessons that come out of the cases specifically, although obviously I'm going to be mentioning cases throughout, and there's loads of lessons that come out of the cases, as indeed there always are